as 11 women's organizations representing hundreds of thousands of women told the Supreme Court in 1980, equal rights for women and men include important and equally significant components. One consists of equal opportunity to share benefits and rights previously limited to men in such areas as employment, education, and the political process. But true equality also comprises a second aspect, the equal division of societal obligations and duties. If women do not share these responsibilities, the gains made in achieving rights for women will be threatened, viewed as magnanimous concessions to women's demands instead of prerogatives justly due equally productive members of society. A second fact is also true, however. In any future national emergency, women will likely be drafted, at the very least as medical professionals, some of whom will serve in the most dangerous areas of any war. The Army Audit Agency's 1982 report on enlisted women in the Army accepted the fact that female soldiers will serve in battlefield areas, be expected to defend themselves and their units, and be exposed to the same risks of injury, death, and capture as their male counterparts. Women today will be asked to face these risks. They deserve the full protection of the Constitution behind them. Our next two witnesses will address the two most common misperceptions of the role of women in the military and the impact that the ERA would have on that role. First, Jean Atkins will present a description and analysis of the so-called combat exclusion laws and the application of the ERA to those policies. Second, Dr. Mady Siegel will discuss the impact of an increased utilization of women on the effectiveness of our military services.
Thank you, Carolyn. Although ERA opponents tend to speak of the combat exclusion law as if there were a single statute or uniform policy, in fact, the services operate under a variety of rules and definitions which have been subject to change over the years, are inconsistent among the service branches, and have little or no relationship to actual war planning. Currently, 2 acts of Congress limit the utilization of women by the services. 10 United States Code Section 8549 states that female members of the Air Force, except nurses and other professionals, may not be assigned to duty in aircraft engaged in combat missions. Thank you. 10 United States Code Section 6015 prevents the Secretary of the Navy from assigning women permanently to quote-unquote combat vessels. The Coast Guard, on the other hand, has no restrictions on the assignment of women. Women currently serve in the widest range of shipboard roles on all types of Coast Guard vessels. This means that Coast Guard women in a time of war would be serving in virtually identical positions to those from which their Navy sisters are barred. The Secretary of the Army is free from any congressional restriction on the assignment of women. From 1948 to 1977, all women served either in the Army Nurse Corps or in the separate Women's Army Corps, and jobs in either corps were considered to be, by definition, non-combat. But in 1978, the Women's Army Corps was abolished, and with the full integration of women into the regular Army, a quote-unquote combat exclusion policy was developed. This policy barred women from assignment to infantry, armor, cannon field artillery, combat engineer, and low-altitude air defense artillery units of battalion or smaller size. Women were also barred from all military occupational specialties which would be concentrated in such units. 38 job categories were closed to women as a result of this policy. Upon the request of Congress, the Department of Defense in 1978 submitted to the Speaker of the House of Representatives a letter providing definitions of combat for purposes of these exclusions. This letter makes clear that women have served in and will continue to be assigned to combat zones or hostile fire zones. The policy was thus not designed to keep women away from combat as it was defined for other purposes, but away from what the Department of Defense now termed close combat. In 1981, the Army further refined its policy by creating a new category of activity, direct combat, and has since analyzed all job specialties and units to determine the relative probability of a soldier routinely engaging in such direct combat. As a result of this analysis, in 1982, 23 additional specialties were closed to women. These actions by the Army to further restrict the roles of women pose 2 problems. First, the battlefield analysis on which these closures were based appeared to be premised on a static war plan with traditional World War II frontline fighting, in direct contradiction to current scenarios upon which battle strategies are being formed. The Army's 1982 Operations Manual explicitly presumes heavy fire in the rear as well as the front of any battle. Thus, by removing women from jobs only at the so-called front, the Army failed to increase the protection of Army women while severely impairing their career opportunities, skills training, and promotional chances. Second, it almost immediately became clear that replacing skilled women in the newly closed fields was not going to be easy. Reports that the Army was re-examining the decision to close one specialty, one with a high percentage of trained women already in place, began almost as soon as the closures were announced. And indeed, on the 17th of this month, it was announced that 13 specialties were determined not to be direct combat jobs after all and were to be reopened to women. It should be noted that the Army's actions to restrict women's opportunities came precisely at a time when their ability to recruit qualified men was much improved due to economic and political factors. The history of the Army's policies regarding women leads Wheel to the conclusion that it is the perceived level of need for women's skills, not their protection, which ultimately drives the definition of combat. We predict that in future years the restrictive policies will be similarly fluid, because defense strategists know that no branch can afford to be bound by artificial rules against the utilization of qualified women in times of national emergency. Applying the essential principles of equality to our national defense policies would break down these artificial barriers. First, the explicit gender-based exclusions, that is, the 2 congressional limitations on women's assignment, the express exclusionary policies of the services, and the gender-based selective service laws would fall. Moreover, any practices based on physical characteristics unique to one sex would have to be justified by a showing that their need was compelling. Determination of fitness for service in a particular job category or unit would have to be made on gender-neutral grounds. Second, to the extent that such gender-neutral criteria might disproportionately exclude women from participation, those criteria would be subject to rigorous examination. Congress would be obligated to assure that such standards were indeed job-related, that is, that the qualities measured were necessary to the efficient performance of the military role in question. These 2 principles would increase, not decrease, the government's ability to assure that the most capable soldiers were available for any given military job. Moreover, claims that these equality principles are too rigid are unfounded. Personal privacy rights would be balanced where they might come into conflict with the equality principles. This analysis rejects, in the context of explicit gender-based policies not related to privacy issues or to physical characteristics unique to one sex, any special allowance for national security interests as overriding the basic principle of equal rights. I submit to the subcommittee that no such doctrine would allow overt classifications on the basis of race to be upheld today. It should be noted that despite the historical difficulties of racial integration of the service branches, no exclusionary or segregationist policies exist today, nor could they withstand even the most minimal constitutional scrutiny. Certainly, the public safety aspects of the government's activities in this area would be part of any analysis of neutral standards or of policies regarding unique physical characteristics. This does not mean, however, that Congress would be free to give approval to military decisions which served only to perpetuate inequality and which were unnecessary to the efficient operation of the armed services. With or without the ERA, the military can always make policy decisions with mission readiness as their primary objective. The mistaken assumption is that such readiness must be at odds with equal treatment under the law. To date, the exclusionary policies implemented by Congress and the service branches, in fact, have not been based in factually supported concerns for national security, but rather in stereotypes, myths, and a barely concealed desire to preserve the image, if not the reality, of national security as an exclusively male responsibility.